The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so here we go. Today with us, Greg Bellman of Weber, Dickey & Bellman at Young Street in Cincinnati. And of course, we have Don and Dan Moore, the Moore Law Firm on Nimitz View Drive. 513-232-2000. Of course, you can get all the information on fox19.com. Click on the Moore Law tab. All the information about all the attorneys who we've ever had on the show, as a matter of fact. So we are back just for a few more minutes, and you wanted to talk to the viewers a little bit about something that's pretty common. If common to you, I have not heard of it. In-running pinch point. It's not good. That's all I know for sure.
You got it. It's not good. Look, in-running pinch point is one of many types of hazards that industrial employees face every day. An in-running pinch point, I've got a picture here that kind of gives you an idea. This is a case where a belt runs over a roller, and the employees in this case were required to put an abrasive in there when the belt would start to slip. And if your hand gets caught, the idea of in-running pinch point, it pulls your hand in. In this case, it nearly took his arm off. It did permanent damage. He was terribly injured. And so then the reason I brought this up is actually 3 points. There are 3 ways an employee can potentially recover if they've been injured on the job. First, obviously, workers' compensation. We've been talking a lot about that today. And of course, that's exactly what Greg specializes in. Second, you also have a separate way to collect, and it's called a VSSR claim. And Greg and I will talk about that in just a moment. Third, the potentiality of an employer intentional tort. Basically, that is when the employer does something on purpose and causes injury to an employee, like take away a safety guard, they may be exposed to liability. Now, our legislature and our Supreme Court has almost made the employer intentional tort claims go away completely. But that it still exists, there's still a statute, there's still a possibility. Now, on the VSSR, VSSR stands for violation of a specific safety requirement. And that's something that you've done a lot of, isn't it?
That's correct. It's one of the few things where you can request an additional award under your workers' compensation claim. It's usually an egregious injury where there's a lack of a safety guard, protection of those pinch points, falls from roofs without safety equipment, falls from scaffolding. VSSR, violation of a specific safety requirement, you have 2 years to file that application, and it's something that's found on the Industrial Commission's website. You fill it out. An investigator goes out to the job, goes out to the employer, and they determine, based upon enumerated violations in the Ohio Revised Code, Ohio Annotated Code, whether a violation exists, and an additional award based upon the number of weeks of compensation that you've had in your workers' compensation claim. It could be pretty substantial, but usually a red flag goes up when there's a loss of a body part or a substantial injury, fall, things that should have, it's common sense, really.
Right.
So they should have known better.
So the VSSR kicks in when the employer breaks a specific rule.
That's correct.
Okay.
You have 2 years from the date of injury to file that application.
All right.
Okay. All right, let's go to, let's see, Leonard in Cincinnati. Leonard, you have a question about an injury that happened about 5 years ago?
Yes, I had a back injury 5 years ago on a job, and I just want to know who's responsible for that bill, workers' comp or the company? The company's self-employed. Okay. So I just want to know who'll be responsible.
Now, Leonard, if your company is self-insured, and self-insured is a status, most claims are state-funded claims, which means the Ohio Bureau of Workers' Compensation takes care of them themselves. However, larger employers can request, and it's a privilege to become self-insured if they're large enough and they have enough financial wherewithal to cover those claims. But if your claim is against a self-insured employer and that employer is still in business, you have to pursue those benefits through the self-insured employer. And if you don't get any satisfaction, you file a motion with the Industrial Commission requesting a hearing on the payment of those bills.
Okay. I think we have time. We can do one more call. Don, if you could help me be quick here. You had a question, Don in Cincinnati, about an industrial accident.
Hello?
Hello, Don.
Hey,
Go
what you
ahead.
got, Don?
Hi. Yes, I got hurt on an injury back in May 11th of 2003. It was an industrial accident. And, both my knees were messed up. I had them repaired. And made a settlement on, they made 2 claims, and they made it on one separate claim for the right knee, one for the left knee. And I had 2 surgeries on the left knee, but since I've been deemed as, they took it to court, they retired me, permanently retired me. And
So hey, Don, you know, we're
Yes.
almost out of time. What's your question?
I am represented by an attorney, and the attorney is wanting to do a settlement, one-time settlement.
You know, I am so sorry, Don, but we are out of time. You had some information about Mr. Bellman's phone number. Please check out the More Law tab on fox19.com.
There you go. Yeah, put it on the
And next show, Veterans Benefits, and we will be back here next Monday morning for More Law. Have a good